pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail, pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Horsferry Roads Magistrates Court, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said, we cannot allow people to be tried in English courts, people who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court, and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Mandera, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. That the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justified the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Horsferry versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, assault, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. But you must be satisfied that you have jurisdiction.
way, the chairperson of the Judicial Service Commission is the Chief Justice.
You're not perhaps with your permission.
I do not expect that all the time we
went through. So this is a new issue that...
it's not a new issue, it's been referred to.
We need your ruling.
It's not a new issue.
With your kind permission and with the permission of my learned senior.
Can I be addressed by the two so that we can quickly deal
If I can help refresh your memory, Your Honor. I raised the objection.
My memory is quite fresh.
Yes.
No, I'm saying the reading. He's now going to the reading.
No, just the same. The substance is not changed. The issue is just for the avoidance of doubt.
No, he's reading, Your Honor. Is it necessary?
The chairperson of the Judicial Service Commission, and we are officers of court, is the Chief Justice herself. And this statement the rearrest of an accused person within the precinct of the Rural Law Courts on Friday, 4th July. The facts indicate that the accused had been released suspects use of fire and dignity of the judiciary. Courts are sacred spaces of constitutional adjudication. Your Honor, argument about the impropriety of the rearrest, I personally like to call it simply abduction, and therefore, Your Honor, you historic because if you decide that the two accused persons, they were yet to take a plea because you object to that. In fact, we are calling on Your Honor to discharge them unconditionally, as happened in the case of Rose and Jerry just the other day. So we would argue that, the charges have been preferred, that ODPP has done this, and I appeared in court along with Chief Justice Emeritus, because what Rose and Jerry did was just to accept, to give our opinion with regard to public participation matters that the committee in Parliament dealing with finance had put out to the public. And then she was apprehended, actually abducted, to use the authority of this court so that you will enter the annals of history as one judicial officer who chose to stand for that constitution of this country. And various aspects have been addressed. Article 20 of the Constitution, for example, which binds all state actors to observe the Bill of Rights, International Bill of Rights, which is part of our domestic law now.
It's a quick question, Council.
Yes.
If I were to make my decision in order to enter the annals of history,
Yes.
would that be making a decision for personal interest?
No, indeed not. Indeed not. You will.
We agree with you.
I'll guide you on that one. It is simply that you apply your mind to the conversation that has appeared before you, that has been proffered before you, and to be able to apply the law judiciously, because that is what we're asking you to do. But in so doing, you will also be capturing the moment in our country's history. Right now, judicial notice should be taken of the fact that we are a country at a crossroads, and all of us have to do something to save it. We are simply saying we object to the practice of the Director of Public Prosecutions arresting Kenyans, bringing them to this court and charge them under the Terrorism Act. That is intimidation of a sort that cannot be tolerated. In fact, it is inflaming of the country. Your Honor, I want to say that these two persons, they're actually not necessarily leaders, council, but they are officials of the Democracy for Citizens Party. And the very fact that the whole country is witnessing a situation where two young officials of a party are charged with an attempt is being made to charge them under the Terrorism Act. It's actually inflaming the country. You see some of us, Your Honor, appearing before you with great humility. They're sending a message. They're sending a message that somebody has to do something to ensure that this remains a country under the rule of law. This is not going to be a country where political actors, finding that they're losing ground, decide to deal with the opponents. Soon after this, Your Honor, a member of parliament, a sitting member of parliament, I should not be saying this. It's important for you to know so that as we expand that. A member of parliament from Manyata